What's up everyone, my name is Nanad and I'm a legal intern at LEXIS and Company. I'm also a student at the Maharashtra National Law University, Mumbai. In today's video, we're going to be looking into some differences between the ownership and authorship of a copyrighted work. So let's get started. Ownership and authorship of a copyrighted work, some copyrighted material, are very intricately aligned and yet simultaneously different facets of the same. As per the general rule, the author, the creator of a work, is the first owner of the copyright of the work. But the copyright law provides certain exceptions to the general rule mentioned above. Now, these certain exceptions become very necessary to properly examine the two different concepts of ownership and authorship, especially in the context of India. As an illustration, if a painting, for example, or a photograph or a portrait is made in the instance of any other person for a certain valuable consideration, then such other person would definitely be considered the first owner of the copyright of the work. Now, the creator or inventor of an idea for a particular creation or invention is not the first owner of the copyright of the work unless they are the creator or inventor of the work itself. As per section 17, the author of a work is definitely the first owner of a copyright, but as stated before as well, this rule is subject to certain exceptions. Now, these exceptions are: number one, the case of literary, dramatic, or artistic works. Now, Section 17A of the Copyright Act of 1957 talks about how any literary, artistic, or any sort of dramatic work that is made by an author in the course of their employment or service by the owner of a magazine, let's say, or a newspaper, or any similar sort of periodical under a contract or service or traineeship for the purpose of publishing or for the purpose of display the work of an author in a newspaper, magazine, or such periodical, the owner, that is the employer or the owner of the employment agency, would become the first owner of the copyright. Number two is the case of a photograph, a painting, a portrait, an engraving, or any sort of cinematographic film. Now, as per Section 17B of the Copyright Act, any sort of photograph, any sort of cinematographic film, or any other painting or portrait taken or made under the course of employment or at the instance of any other person for some sort of consideration or some sort of benefit in return. Such photographs or such other paintings or portraits are to be considered as the property of the person at the behest of whom such photographs or such portraits or such films have been made. That is, the person at the behest of whom these have been taken or made becomes the first owner of the copyright. Now, the third one is a summation of the first two rules that I've mentioned before. So, Section 17C of the Copyright Act provides this general rule and states that any sort of work done during the course of employment or any provision of any service or any sort of traineeship, the employer, the proprietor, in that particular case becomes, in absence of any other prior agreement to the contrary, the first owner of the copyright. Number four talks about lectures that have been delivered in public or any sorts of speeches. Now, as per Section 17CC of the Copyright Act, in case where any person has delivered any sort of speech or any address in public, the same person that has delivered the speech or address will be the first owner of the copyright. But in case the speech or address has been delivered on behalf of some other person or in the backdrop of an employment related responsibility towards such other person, then such other person would become by default the first owner of the copyright. Number five talks about the government work, that is under Section 17D of the Copyright Act. In case of any form of government work, that is any form of work that has been undertaken as part of any sort of government initiative, in absence to obviously any sort of prior agreement to the contrary, it will be so that the government will become the first owner of the copyright in relation to all such work. The same is also true in a case of any work done under any particular or any specific public undertaking that becomes part of the government work in general. Now, lastly, as per Section 17DD and Section 41 of the Copyright Act, in the cases of any kind of work done for any sort of international organization, the international organization itself becomes the first owner of the copyright. Hence, although in general the author is and always will be the first owner of the copyright for their own work, there are many such instances, as I've mentioned throughout this video, that make out a clear difference between the author of the work and the owner of the work. So that is all for this video. I hope you learned something from it. Do like, share, and subscribe if you did. And also comment down below all sorts of questions, suggestions, any queries, or any just thoughts that you have about the video. It helps us out a lot. That's all. Thanks for watching, and I hope you have a good one.